Ever since the International Court of Justice began hearings on February 19 in a case against Israel's decades-long occupation of Palestinian territories, country after country, at the United Nations top court, declared the Israeli actions as illegal, with some equating it with apartheid.
Israeli apartheid must end.
Until the United States took the stand.
It is more urgent than ever to proceed to a Palestinian state, one that also ensures the security of Israel and makes the necessary commitments to do so. In light of these considerations, the court should not find that Israel is legally obligated to immediately and unconditionally withdraw from occupied territory.
Previous speakers have demanded that Israel end its occupation of the Palestinian territories, which came after its victory in the Six-Day Arab-Israeli War in 1967. Washington's comments came as it vetoed a UN Security Council resolution a day before, for the third time calling for an immediate ceasefire in Gaza, where its ally Israel is waging a war. The U.S. said it felt the resolution would sabotage ongoing negotiations between Hamas and Israel on a ceasefire in Gaza and a prisoner hostage release deal, even though the draft was supported by the two countries, Egypt and Qatar, which are leading the mediation efforts between Tel Aviv and the Palestinian armed group. The U.S. argument at the World Court on the third day of the hearing didn't go down well with the Palestinian foreign minister, who was present at the hearing. He dismissed Washington's assertion that the court's advice against Israel could sabotage ongoing negotiations between Hamas and Israel on a ceasefire in Gaza and an eventual recognition of a Palestinian state. Speaking to the press at The Hague, Palestinian Foreign Minister Riyad Malki said, "We tried other forums for the last 75 years, and we confronted exactly them, the U.S. veto and the U.S. hegemony over the decision-making process within the UN system. And that's why we came to the ICJ, because we felt that the Americans cannot perform in the same way they have performed in the United Nations system." Meanwhile, the U.S. legal advisor for the Department of State further urged the judges to stick to the UN framework for a two-state solution.
Others have asked you to broadly construe the questions and the law. They have asked you to try to resolve the whole of the dispute between the parties through an advisory opinion addressed to questions focusing on the acts of only one party. The United States disagrees with that this approach would be consistent with the court's role within the United Nations or the established UN framework for achieving peace through negotiations.
Political analysts see America's argument as a message to the court that it should act in favor of the U.S. and Israeli strategy of negotiation so far as Palestine is concerned and not the other way around. The United Arab Emirates, while presenting its case in court on the same day as the U.S., argued that international law must apply equally to all.
International law cannot be an a la carte menu. It must apply equally to all. And it is all the more essential in the long shadow cast by the Palestinian question, an injustice that has persisted for more than 7 decades, and which implicates the most fundamental principles of the international system, of self-determination, of human rights, and of our most basic and universal yearning for peace, justice, and freedom.
Another Arab nation, Egypt, which is deeply involved in a mediator role in the negotiations between Israel and Hamas, called Israel's occupation a continued violation of international law. Israel's assault on the besieged enclave has killed more than 29,000 Palestinians, mostly women and children, and displaced more than 80% of its population since the October 7 Hamas attack on southern Israel, which killed 1,139 people, and some 250 were taken hostage. In a first-of-its-kind case, a total of at least 52 countries will be presenting arguments on controversial Israeli policies in the West Bank, the Gaza Strip, and occupied East Jerusalem. It's the largest number of parties to participate in any single ICJ case since the court was established in 1945.
The entirety of Israel's colonial occupation regime is on trial today. Not just the apartheid, colonization, and persecution by which it is brutally imposing it on the Palestinian people. An unprecedented number of countries are participating in the proceedings. taking a stand for justice and peace. This is a clear reflection of the global concerns and calls to bring an end to this abhorrent illegal regime immediately and unconditionally.
The historic case was triggered by a request from the UN General Assembly on December 30, 2022, when a majority of members voted to seek the court's opinion on the legal consequences of the continuing Israeli occupation of Palestine. Arab countries, Russia and China, voted in favor of the move, while Israel, the US, Germany, and 24 others voted against it.